Hi, good morning, good afternoon, good evening, whatever time it is. As always, happy whatever day it is. Welcome to Left Side of the Aisle. I'm your host. My name, as always, is Larry Erickson. And for the next half hour, I'm going to be going on and on about things that I think are important and to which you should pay some attention. As always, again, if you have any comments, questions, reactions, whatever, you can email to them, should email them to me directly. The email address is whoviating, WHOVIATING @AOL.com. And you can also, if you prefer, go to my website, Lotus Surviving a Dark Time. You can get the email address from there, or you can leave a comment right there if you like. As always, again, if you do email me, two requests. One, be sure to include something in the subject line that makes it clear this is not spam. And two, be a little patient about getting an answer because I actually am rather slow about answering my email. So, let's get to it. I always say that I like to start with some good news where I can, and this week I've got some good news, but in some ways, rather than good, it's more like it's hopeful news rather than good news. The first part of which is filed under the heading, Even in Texas. On May 28th, the City Council of Houston, the nation's fourth largest city, passed an equal rights ordinance, which creates non-discrimination practices and policies for a number of protected classes, including sexual orientation and gender identity. These protections cover employment, housing, and public accommodations. Houston is the fifth city in Texas to adopt such an ordinance, following Austin, Dallas, Fort Worth, and San Antonio. Now, the state of Texas as a whole continues to be an ethical backwater, as exemplified by Big Earl's Bait House and Country Store, and yes, that is the actual name, Big Earl's Bait House and Country Store in Pittsburgh, Texas, which recently banned a same-sex couple from ever returning to the restaurant, citing a policy of only serving men who act like men. Management then proceeded, when they got some flack, to defend a server who was accused of telling the couple, "We don't serve fags here," by tut-tutting that what she actually said was, "We don't like fags," as if that was supposed to be a whole lot better. Even so, despite places like Pittsburgh, Texas, Houston, which is one of the last large cities in the country to not have a non-discrimination policy, now has one. And it's one that actually includes the recognition and the reality of how society is changing. On another front, Wisconsin Governor Scott Walk All Over You, who has long backed Wisconsin's ban on same-sex marriage, is suddenly getting all squishy about the issue. This likely has something to do with the fact that he's facing a suit in federal court challenging the ban, a suit the state is already preparing to lose. So despite his long support for the ban, he's now saying, well, golly gee whiz, he doesn't know if this ban violates the U.S. Constitution. He doesn't know if the ban would be approved by voters if it was voted on today. He doesn't even know if it would really be a big change if the ban was overturned. And what's more, he's certainly not going to try to tell a federal judge what to do about it. Which is weird because his administration is now in court defending the ban, which means they are telling a federal judge what they should do about it. Well, the bottom line here, it means that openly endorsing the ban on same-sex marriage in an election year is a political liability of which Walk All Over You wants no part. There's one other bit here, one other bit of news related to this, and this is more philosophical, but for that reason, it's maybe in some ways more meaningful. Around the end of March, I noted the death of Fred Phelps, who at the time I described as, quoting myself, a notorious and gross bigot, founder of the notoriously and grossly bigoted Westboro Baptist Church, which isn't a part of any Baptist convention and isn't really a church but more like a family cult. Now, at that time, I noted that last summer, Phelps had been excommunicated from his own church for reasons that are basically unknown, but which apparently revolved around him urging kinder treatment of fellow church members in the wake of an internal power struggle. Well, now there's a new wrinkle to this story. Several weeks ago, Zacharias Phelps Roper, Phelps's grandson, bolted from the group. And something over a week ago, he said that on the day Phelps was excommunicated, he stood outside the front door of the church and said, not loud enough for anyone other than a few nearby church members to hear, but he said, "You are good people." Now, why is that important? Because the sentiment was not directed at members of his church. It was directed across the street at the Equality House, the rainbow-painted house directly opposite the compound of the Westboro Baptist Church. It's run by a group called Planting Peace, which, among other things, advocates for LGBT rights, the very thing the Westboro Baptist Church most hates. Now, it remains true that Fred Phelps lived his life as a notorious and gross bigot. But as one person said, if even he at some point could be moved, then there is no heart out there that can't be. You know, Martin Luther King has often been credited with the saying, the moral arc of the universe is long, but it bends toward justice. And he did say that, at least once, in speeches. But the term seems to have originated with a man named Theodore Parker, who was a 19th century Unitarian minister and anti-slavery activist, who in 1857 published a book of 10 sermons on religion. And in one of those he said, and I'm quoting here, "I do not pretend to understand the moral universe. The arc is a long one. My eye reaches but little ways. I cannot calculate the curve and contemplate the figure by the experience of sight. I can divine it by conscience. But from what I see, I am sure it bends toward justice." Our eyes can still see but a little ways, but in the case of LGBT rights, I think we can clearly see that bend toward justice. And that is good news. All right, going right on from there, sort of flipping to the other direction, one of our regular weekly features, it's the Clown Award, given for meritorious stupidity, and oh my, have we got a winner this week. The winner of the Big Red Nose this week is the American Family Association, founded and headed by Donald Wildman, an anti-gay bigot with a history of anti-Semitism. Now, that fact alone about Wildman would be enough for a Clown Award, but we have a particular reason for this being the week. To explain why, we have to take a step back and talk about someone else entirely. His name was Harvey Milk. Now, for folks my age, at least those who are politically involved, the name should at least ring a vague bell. Harvey Milk was born in New York in 1930. He moved to San Francisco in 1972. By 1975, he was a political force in the city, an outspoken leader of the city's gay community with deep connections to city government. In 1977, he was elected to the San Francisco Board of Supervisors, becoming one of the very first openly gay elected officials in the United States. As a member of the board, he actually tackled a wide variety of issues besides gay rights, including child care, housing, and a civilian police review board. The thing is, also elected in 1977 was somebody named Dan White, a conservative who frequently argued with Milk over board policies. In 1978, a year after he was elected, White resigned from the board, saying that the pay wasn't good enough. Well, prodded by his supporters, he changed his mind about resigning and asked Mayor George Moscone to reappoint him. Moscone refused, which to White meant that Moscone and Milk were driving San Francisco downhill with their liberal policies and tolerance of homosexuality. So on November 27, 1978, Dan White snuck into City Hall with a loaded revolver. He got into an argument with Moscone, and when Moscone again refused to reappoint him, White shot him twice in the chest and twice in the head, killing him. White then went down the corridor and murdered Harvey Milk, shooting him twice in the chest, once in the back, and twice in the head. At his trial, White claimed diminished capacity and was convicted of voluntary manslaughter. He served only 6 years. Now, all of this is relevant because in recognition of his work for advancing human rights, the U.S. Postal Service recently issued a Harvey Milk postage stamp. Which brings us back to this week's clowns. The American Family Association has declared that the stamp came as, I'm quoting, a result of 7 years of lobbying by a self-described drag queen and former transsexual prostitute, and that the stamp honors a child predator. Therefore, the group says, its members and supporters should refuse to buy the Harvey Milk stamp, and, get this now, if any mail bearing the stamp arrives at their home or business, they should refuse to accept the mail, mark it return to sender, and tell the postal carrier that they will not accept it. Because apparently the stamp has some kind of gay cooties, which are, I don't know, infecting the letter or something. Some people actually are now suggesting sending a letter with the stamp to the American Family Association with the outside of the envelope marked donation enclosed. Somebody called that 49 cents worth of fun. Actually, if you want to join in that fun, the address of the American Family Association will be available at my website. In any case, one thing is clear. Donald Wildman and the American Family Association, you have become the new definition of clown. And we are taking a break. Welcome back. Not that you had time to go anywhere. Speaking of time, now it's time for our other regular weekly feature. It's the Outrage of the Week. And this week, the target of the outrage is an institution that unfortunately has been the target of too much outrage while I've been doing this show, the Supreme Court of the United States. Talk about this, it's going to take a while because there's some background and fill we have to do for explanations, but we start with the fact that James Holmes is the man who stands accused in Colorado of the murderous rampage at a movie theater in Aurora, Colorado in 2012, in which he is accused of killing 12 people and wounding 70 more. The judge in that case put a gag order on things, but someone involved leaked information about a notebook depicting violence which Holmes had sent to his psychiatrist. Defense attorneys said that that leak affected their client's opportunity for a fair trial, so they wanted Fox News reporter Jana Winter to be forced to testify about her source for the story. Well, the New York State Supreme Court said she was protected by New York's strong reporter shield law, and Colorado prosecutors could not force her to testify there. Colorado appealed to the Supreme Court, and to its credit, on May 27th, the court refused. Just 6 days later, that same court said that federal prosecutors can force New York Times reporter James Risen to testify about his source for a story under pain of a contempt of court citation and fines or a prison sentence of truly, literally indeterminate length. And no, the difference here is not one of Fox News versus the New York Times. The difference is one of defense attorneys trying to protect a client who's accused of murder versus a federal prosecutor screeching about national security, the magic incantation that makes judges' brains turn to oatmeal. Here's the background of this. Back during the Shrub administration, some in the intelligence community linked to Risen classified information about a covert U.S. operation to undermine Iran's supposed and probably non-existent nuclear weapons program. This plot involved using a former Russian scientist to pose as a rogue nuclear mercenary in order to deliver faked plans to the Iranians. Now, Risen wrote a news story about the operation, but the Times editor spiked the story at the request of the director of the CIA and Bush's national security advisor. In 2006, Risen's book, State of War, was published, and in that book, he talked about the Iranian operation, which that account made clear was actually botched. Well, subsequently, federal prosecutors charged Jeffrey Sterling, a former case officer who ran that Iranian operation, with being Risen's source, and they filed multiple felony charges against him. Now, they had a fair amount of evidence about him being the source, including phone and email contacts between him and Risen, and the fact that in his book, Risen sometimes told the story from the perspective of a person in the position which Sterling occupied. But that wasn't enough. No. The feds wanted to force Risen to sit in court and to say, Jeffrey Sterling was my source. That is, they wanted to force him to betray his promise of confidentiality and turn in his source in order to save his own skin. Now, are they doing this because they needed his testimony? Because they couldn't get a conviction without his testimony? Well, if that's the case, then why now, after the Supreme Court has chosen to let stand an appeals court ruling that there's no such thing as so-called journalistic privilege, no such thing as a journalist's right and ability to protect their confidential sources in the face of a subpoena? If that was the reason, then why now is there still a question about whether or not the prosecution is actually going to call Risen to testify? And what's more, the appeals court flat dismissal of journalistic privilege flies in the face of the facts. The claim is based on a 1972 Supreme Court ruling called Brandsburg v. Hayes, in which the court ruled 5-4 that there was no absolute constitutional protection for reporters. The thing is, one of those five was Lewis Powell, who filed a separate concurring opinion to emphasize, quoting him, the limited nature of the court's holding. He wrote that there should be a balance, and quoting him, between freedom of the press and the obligation of all citizens to give relevant testimony. In other words, he was saying that the question of privilege should be decided on a case-by-case basis, not simply dismissed out of hand. The appeals court was clearly wrong, and the Supreme Court did not correct it. Frankly, I also think that the Supreme Court was wrong in Brandsburg. I think there is such a thing as a journalistic privilege, and to explain why, I have to go to another part of the First Amendment, that about free speech. Okay, back in May of 1971, there were a series of demonstrations in Washington, D.C. against the Vietnam War. It was called May Day. It was 3 days of rallies, protests, and nonviolent civil disobedience. There were over 15,000 arrests during that time, including 7,000 on the first day. Virtually all of those arrests, it turned out, were either illegal or illegally conducted, and the city actually lost several civil suits as the result of this. The thing is here, on the third day, there was a large rally on the steps of the Capitol, which spilled out onto the Capitol lawn, where a few thousand people were listening to speeches, including by members of Congress. Bella Abzug was one, Ron Dellums was another, and I forget the rest of them. The thing is, this group had every right to be there. This was an entirely legal gathering. Members of Congress have the authority to invite people to attend a speech that they are giving at the Capitol, even if that invitation goes out to several thousand people who wind up sitting on the lawn. Despite that, the D.C. police began arresting the audience. Now, actually, I know about this directly because my first wife was among those arrested in that crowd. To show you how absurd this all was, the actual charge written on her arrest form, the actual charge, and this is an exact quote, the charge was doing certain things on Capitol grounds, quote unquote. Now, needless to say, those charges were dropped and the arrest became one of the civil suits which the city lost. But here's the point of all this. Another suit that arose out of that same incident was filed by those members of Congress who charged that the D.C. police had violated their right to free speech. The city responded, "Of course not. We haven't done anything to inhibit you from speaking." But the courts agreed that the right of free speech has no meaning absent a right to be heard. By wrongfully denying them an audience, the police had violated their free speech. Now, the point is, a right to be heard is clearly part of a right to speak. Now, the First Amendment doesn't say that. It doesn't say that, but it must mean that in order to mean anything at all. Back in 1965, there was a Supreme Court case of Griswold v. Connecticut. This was a landmark case because it established the constitutional right to privacy, even though privacy is mentioned nowhere in the document. Justice William O. Douglas, writing for the majority, said the right was to be found in the penumbras of other constitutional protections. Now, penumbra is the partial shadow cast outside the full shadow cast by an opaque object. We most commonly hear the term, in fact, with regards to partial lunar eclipses, when the moon is actually in the fringe of the Earth's shadow, not right in the full shadow. The point Douglas was making on the behalf of the majority was that the protections in the Constitution cast a sort of legal shadow to encompass principles not expressly stated in the document, but without which those protections would lack real meaning. All right? Go back to the First Amendment, and then back to freedom of the press. The famed journalist and my personal hero, I.F. Stone, is the source of the truism, "all governments lie," which also means that all governments will try to hide from you things you have a right to know, more importantly, to hide from you things you should know. But as a practical matter, the only way that usually happens, the only way those hidden things get into light, in most cases, the only way that happens is that someone who does know about it but isn't supposed to tell anybody about it does it anyway, tells it, leaks it as an anonymous source to someone who's in a position to spread that information more widely. That is, they leak it to a member of the press or to somebody who has connections in the press. Without that process of someone who knows saying what they should not say, telling what they should not supposed to tell, without that process, we are left with a media consisting essentially of only what the government is willing to have said. Now, it is safe to say that in such a case, some of what we see, hear, and read, the government would be happy to be out there because it serves the government's purposes. A great deal of it, most all of it, the government wouldn't care one way or the other about it. And for some of it, the government wouldn't like it being seen, heard, or read, because this would not put an end to criticism of the government. But it would put an end to a type of informed criticism of the government, and it would mean that everything out there for us to see, hear, and read is what the government is willing to have. Not that necessarily that it's happy that it's there, but it's willing to have it there. Okay, here's the question. In that case, is there any such thing truly as freedom of the press? Is the press truly free when all that it says, because all that's available to be said, is what the government is willing to have said? Again, not necessarily wants to have said, but's willing to have said. Is there such a thing as freedom of the press that does not include the ability to uncover and report on things the government would rather we not know? Which in turn raises the next obvious question. Given that, how can we expect those anonymous sources who are the means by which we discover those hidden truths, the sources who are not prepared to sacrifice their jobs or go to prison by going public, but who want to get this story out, how do we expect them to do this, to take that risk of discovery, if those to whom they tell the secrets can be compelled to give them up at the whim of some prosecutor? It seems to me that journalistic privilege is clearly within the penumbra of freedom of the press. Just like freedom of speech is meaningless without the freedom to be heard, so too is freedom of the press, absent the right of the people to know, and that right is at least greatly circumscribed, absent the ability to protect confidential sources. And this is where the outrage comes in. There is no way that the members of the Supreme Court do not know all of that. They cannot not know the effect of denying reporters' ability to protect their sources. They cannot not know the impact, the chilling impact, forcing reporters to testify will have, not on the reporters, but on the sources, those people the journalists depend on for information, the people we all depend on to reveal what should be revealed, to stop the concealment of what should not be concealed, to let us know what we need to know. They cannot not know of what Risen's lawyer, Joel Kurtzberg, called, quoting him, countless stories of tremendous historical significance which never would have been written without the reporter's ability to promise sources confidentiality and keep those promises. Kurtzberg, he cited, quoting him, the Watergate break-in and cover-up, the abuse of prisoners at Abu Ghraib, the CIA's waterboarding of terrorism suspects, the existence of secret CIA prisons in Eastern Europe, the NSA's use of warrantless wiretaps on U.S. citizens, and the systematic lack of adequate care for veterans at Walter Reed Army Medical Center as just a few examples. And I'm sure any one of us could come up with our own list. Now, it's true, there is no specific guarantee of a journalistic privilege in the Bill of Rights. But neither is there a specific reference to privacy anywhere in the Constitution, and despite the recognition of the existence of such a right, the Republic and the Constitution both appear to have survived. The importance of the journalistic privilege is great enough that 49 states and the District of Columbia have some form of a reporter's shield, either a law or a court-recognized privilege or both. And those shields serve to protect reporters from having to testify about their sources. The problem is that applies to state courts. Risen's case involves a federal court. And despite the fact that there's been a lot of talk about a federal shield law, the House has passed versions of a shield law in the past. The Senate Judiciary Committee has passed versions of a shield law in the past. Despite that, a lot of talk about a federal shield law, and despite a lot of talk about such a shield law being passed this year, the fact remains there isn't one. Which leaves us with the court privilege, which is what now the Supreme Court wants to deny. So think of what we would not know that we should know. Think of what we never would have known, never could have known, if reporters had not been able to tell their sources, you will be protected. There is no way the members of the Supreme Court do not know the meaning of what they have done here, and apparently they simply do not care. And that is an outrage. All right, I think I'm going to make that, I probably got about, 2 minutes, minute and a half, something like that left, so I'm going to make that it for today. I'm not going to go into anything else. I will rather take the time for the moment to remind you that we're going to be doing something over these next several weeks. We're going to start doing a quarterly show, on 4 times a year, once for each season. It's sort of the version of And Another Thing. And Another Thing will still be part of this show, but there's going to be a quarterly show about cool science stuff. So look forward to that. It will be coming. But for the moment, I'm just going to say, as always, you have the best week you possibly can. Peace.